If you believe you are anonymous online, or that your activity is simply too vast and fleeting for the government to track, you are operating under a dangerous delusion. You assume clicking I agree is just a routine, meaningless step. Stop scrolling now. Because that assumption is fundamentally incorrect. In the next 15 minutes, we are going to expose 50 absolutely mind-bending, old, and brand new statutes across the United States. These laws are quietly lurking, ready to create severe legal trouble for you just for clicking a link, sharing a photo, or even submitting a review. Did you know that in one state, posting a specific image could result in months of jail time? Or that criticizing a business online could be interpreted as a criminal act? It is time to confront the uncomfortable truth. The biggest myth about the digital world is that it exists outside the jurisdiction of physical law. Welcome back to the Freaky Laws channel. Today, we are undertaking a massive legal expedition into the regulatory maze that governs the internet. We all live online now. It is where we communicate, shop, consume media, and form opinions. Because we spend so much time here, we instinctively treat the internet like a realm of pure freedom, governed only by the code it's built on. But this couldn't be further from the truth. The legal codes of the United States, the ones written on paper, signed by governors, and interpreted by judges, are struggling to keep up with the blinding speed of digital evolution. And in their effort to catch up, they often create rules that are either absurdly specific or completely out of touch with modern technology. Our mission today is to document 50 freaky internet laws, a collection of state, federal, and local regulations that are so strange, so hyper-specific, and so often ignored that they will make you immediately rethink every single interaction you have had with a keyboard. Some of these laws are trying to protect consumers, some are trying to protect businesses, and others are simply relics of a bygone era. They all share one trait: they are weird. We cannot waste a moment. We have 50 statutes to analyze. Before we proceed with the first list of 10, I have a quick request. If this strange blend of law and technology captures your interest, please take a moment to subscribe to the channel. Give this video a like and let me know in the comments which of these 50 laws you found the most shocking. It is the easiest way to support this deep dive research and ensure we keep bringing these unbelievable legal oddities to you. Now, let's step into the legislative rabbit hole. The core challenge we face is this: the digital world is dynamic. The legal world is glacially slow. When legislators, often not the most tech-savvy individuals, try to regulate phenomena like data privacy or online harassment, they are forced to use the language of physical law. This adaptation often results in legislation that is either overbroad, capturing innocent behavior, or so narrowly defined that it is obsolete before the ink is dry. The laws we are about to explore fall into four crucial categories of legal clumsiness. 1. Overreach: laws that attempt to govern the global, often encrypted, and instantaneous nature of digital communication using rules designed for local, physical interactions. 2. Obsolescence: statutes passed in the late 1990s or early 2000s that were based on outdated technology models, yet still remain technically enforceable today. 3. Bureaucratic folly: regulations that drill down into tedious, hyper-specific administrative details, turning simple online transactions into complex legal compliance issues. 4. Reactionary policy: legislation born from panic after a highly publicized event, often passed without the careful consideration needed for a medium as complex as the internet. We will break these laws into 5 distinct blocks of 10, gradually building up the intensity of the legal weirdness. These are the statutes that regulate basic, daily online behavior, proving that even mundane digital tasks carry hidden legal risks. Law 1. The Nevada email timing restriction. In Nevada, if you operate a business, there are specific, highly structured regulations regarding when exactly a commercial email can be delivered. This goes far beyond the standard anti-spam rules. The compliance details are so minute that a business could technically violate a state statute. simply by scheduling a promotional email to deploy at 11:59 p.m., causing it to cross a legal midnight threshold. The law attempts to impose a fixed, physical world delivery schedule onto the fluid, instantaneous nature of digital mail. It treats your inbox like a regulated physical mailbox with strict hours of operation. Law 2. The prohibition on demanding social media passwords. Multiple states, most notably California, have felt the need to pass laws explicitly, forbidding employers from demanding access to a job applicant's or employee's private social media accounts, often by asking for their passwords. The truly remarkable thing about this law is that it had to be legislated at all. The very fact that employers felt empowered to request the keys to a prospective employee's entire private digital life underscores a severe privacy crisis that the government had to step in to solve. It's a protection we should never have needed. Law 3. The untruthful online review statute. While a consumer's freedom of expression is protected, state laws consistently prohibit posting a review that is knowingly false and intended purely to inflict economic harm on a business. This is where traditional libel law gets a digital upgrade. The freaky part is the resulting courtroom chaos. Businesses will spend fortunes attempting to discover the real identity of a commenter who left an aggressively negative, anonymous review, all to prove that the statement "this restaurant gives you food poisoning" was a deliberate and damaging lie, rather than just a subjective complaint. The internet comments section is now a courtroom. Law 4. New York's aggravated cyber harassment charge. New York State employs a specific statute for aggravated cyber harassment. The severity of the potential penalty is significantly escalated if the accused individual has any previous conviction for a related offense. This effectively designates the internet as a high-risk environment for anyone with a past criminal record. It means routine online drama or even an ill-advised rant can quickly transform into a serious, escalating legal matter simply because of the digital nature of the communication and the perpetrator. As history, the law treats an online message board like a parole office. Law 5. The e-waste disposal compliance. Laws at the federal and state level meticulously regulate the disposal of electronic waste. E-waste, treating old computer hardware, monitors, and servers as potentially hazardous materials. The obligation to recycle these items correctly is legally stringent. Forgetting to properly dispose of a few old hard drives can subject a small business to enormous environmental fines. This illustrates the simple fact that the digital world still requires a highly regulated physical exit strategy, and the legal system is watching that physical exit very closely. Law 6. Attempts to mandate digital identity in several legislative bodies, including in Delaware. There have been serious, although often unsuccessful, proposals to pass bills that would penalize or restrict websites that allow users to comment or post content anonymously. The fundamental issue here is constitutional. The U.S. legal system has long recognized the right to speak anonymously, especially regarding political matters. These failed bills showcase an ongoing, disconcerting effort by lawmakers to force the digital world to fully identify itself, threatening a core principle of free speech. Law 7. The lingering video game content law. In Minnesota years ago, Minnesota attempted to pass a law that sought to regulate the sale and rental of certain video games based purely on content, trying to impose age restrictions in the same way physical media like movies are rated. While these laws have typically been struck down in court, their very existence shows the legal system's initial, awkward attempts to police digital entertainment. The law treats a complex interactive digital medium with the same outdated tools used to regulate a movie on a DVD. Law 8. Texas's expansive online impersonation law. Texas holds a notably broad statute criminalizing online impersonation. It goes beyond simple financial fraud catfishing to include creating any profile or online presence using another person's identity, image, or likeness, provided the intent is to harm, defraud, intimidate, or threaten. The law's ambiguity is its danger. It means a clumsy parody or tasteless satirical account could potentially be prosecuted as a criminal offense, making the intent of the creator subject to complex, subjective legal scrutiny. Law 9. Federal power to seize domain names under various federal statutes, particularly those concerning the distribution of counterfeits and intellectual property theft. The government has the power to confiscate a website's domain name, effectively deleting its online presence. The legal moment of maximum impact is when a user attempts to visit a familiar URL and is met not with a website, but with the seal of a federal law enforcement agency declaring the property seized. It is the government's high-tech equivalent of putting a physical lock and chain on a building. Law 10. The federal trap of COPPA compliance. The Federal Children's Online Privacy Protection Act (COPPA) places immense legal burdens on any website or app directed to children. The law mandates stringent rules for data collection and parental consent. The consequence of failure is staggering, with companies paying tens of millions of dollars in fines for accidentally collecting a child's information. If your YouTube channel produces animated content, you are suddenly navigating a massive federal regulatory framework designed to protect minors in a way that turns simple data collection into an extremely high-stakes legal gamble. These laws show us how outdated analog legal concepts are being stretched and contorted to fit the modern digital landscape, often with confusing results. Law 11. The Digital Trespass Statute. Laws against trespassing are traditionally rooted in real property entering land without permission. However, many states now employ digital trespass laws, making it a crime to access a computer network or system without explicit authorization. The truly nuanced risk lies in exceeding authorized access. If an employee, using their valid login, accesses a folder they were explicitly told not to view, that could potentially be charged as digital trespass. Your login credentials grant limited access, and violating those limits can be a criminal matter. Law 12. The legal status of digital evidence. State and federal courts are continually grappling with how to treat digital artifacts as evidence. Is a Facebook post the equivalent of a written confession? Can a text message be used to prove intent? The legal freaky factor is the sheer inconsistency. Some judges will accept a simple screenshot, treating it like any paper document, while others demand incredibly complex digital forensic certification to ensure the data hasn't been altered. The law is having an identity crisis about the fundamental reliability of anything presented on a screen. Law 13. The fine print of the Electronic Signature Act design. The Federal Electronic Signatures in Global and National Commerce Act (ESIG) and grants digital signatures the same legal weight as a physical ink signature. This is convenient, but the legal obligation is complex. For an e-signature to be truly valid, the law often requires the signee to demonstrate they intended to sign the document, and they must be given a practical way to save a copy. If you use a quick app to sign a contract that doesn't provide a PDF receipt, you might have grounds to argue the contract is legally void. Law 14. School authority over off-campus cyberbullying. Many state laws empower school districts to discipline students for acts of cyberbullying that occur off-campus, as long as the behavior creates a substantial disruption to the school environment. The chilling implication is the scope of control. A student posting an angry, mean-spirited comment from their home on a Saturday night could face suspension or expulsion on Monday morning. The school's authority, via the internet, has legally extended into the student's private residence. Law 15. Attempts to regulate truth on online dating profiles. There have been various legislative efforts, notably in New Jersey, to mandate that individuals must be truthful about their marital status or criminal history when using online dating services. The absurdity is the government's attempt to legislate truthfulness. In the notoriously subjective realm of romance, how do you legally define a lie about one's height, income, or career aspiration? Well, usually impractical to enforce. The effort itself demonstrates a bizarre application of consumer protection law to personal relationships. Law 16. Advertising restrictions for digital alcohol sales in states with restrictive alcohol sales laws. These regulations extend directly to online advertising. A local bar's social media post may be legally treated like a physical billboard. For instance, if a state bans advertising specific prices for liquor in physical media, that same restriction can apply to a photo posted on Instagram. The law insists that your fluid, digital social media feed must adhere to the same rules as a stationary, printed sign from the 1950s. Law 17, Louisiana's Digital Deception Statute. Louisiana has a law specifically designed to make it illegal to use the internet to deceive a minor into committing a criminal or delinquent act. While clearly aimed at protecting children, the legal scope of the word deceive is incredibly broad. It could potentially encompass a wide range of manipulative online behavior that falls short of direct threat but still encourages an unlawful outcome. The law is attempting to police subtle persuasion in the digital realm. Law 18, the Unsolicited Text Message Fine TCPA. The Federal Telephone Consumer Protection Act TCPA is an old law designed to curb annoying robocalls, but it has been aggressively applied to unsolicited text messages. The staggering element is the penalty. Senders can face fines of thousands of dollars per legal text message. This law transforms an annoying spam text into an incredibly high-value legal liability, frequently resulting in lucrative and very large class action lawsuits against companies that get their messaging strategy wrong. Law 19, the intricacies of online gambling bans. Even as many states move to legalize various forms of online sports betting, many state statutes still contain broad, restrictive language banning any form of online gambling. The complexity rises when these laws are applied to casual, small-stakes online poker games or non-professional fantasy sports leagues that operate outside state-licensed jurisdictions. Your personal game night, depending on the IP addresses involved, can technically violate a state-specific law that the internet was never designed to respect. Law 20. Legislative attempts to ban self-destructing messages. There have been various attempts by law enforcement and legislators to pass laws that would make self-destructing messaging applications like Signal or Snapchat legally accountable. The argument is that these apps facilitate crime by destroying potential evidence. The truly freaky element is the desire to legally mandate that private digital conversations must be saved and stored, giving law enforcement a perpetual look-back window. It is a fundamental legislative assault on the principle of digital ephemerality. These are the statutes that regulate the tiny, mundane details of online life, the kind of administrative clutter that proves the legal world is paying attention to every click. Law 21, the unofficial font size requirement in California's sweeping privacy laws, such as the CCPA and CPRA, contain exceptionally detailed rules for businesses, including, by regulatory extension, strict guidelines on how a mandatory link, like the "Do Not Sell My Personal Information" link, must be displayed. While the law may not explicitly name Oriel 12, the compliance requirements lead companies to impose internal design standards for minimum size, color, and placement to avoid ruinous fines. The government is effectively regulating graphic design for the purpose of privacy. Law 22, state-specific privacy policy mandates. The Virginia Consumer Data Protection Act (CDPA) requires companies to include unique, Virginia-specific language in their published privacy policies, particularly when targeting or processing the data of Virginia residents. This creates an absurd situation where national websites are forced to craft distinct, state-specific legal prose, transforming a single privacy policy document into a legal patchwork quilt that varies across state lines. The internet's global nature is being forced into localized legal compliance. Law 23, American limitations on the right to be forgotten. While the European Union offers a broad right to be forgotten, the right to demand search engines delist links about you, several U.S. states have attempted to pass highly limited versions. These laws often only apply if the information relates to specific old criminal records, and only if a certain amount of time has passed, and only if the information is deemed irrelevant to public safety. The law tries to be a digital eraser, but one with a long, confusing list of exceptions that make it nearly unusable. Law 24, the unencrypted data notification loophole. State laws universally require companies to notify customers if their personal data is stolen in a breach. However, many state regulations provide a huge exemption if the stolen data was encrypted, meaning it was scrambled and difficult to read. The company often does not have to notify customers. This creates a regulatory incentive for companies to encrypt, which is good. But it also means your encrypted data could be stolen without your ever knowing it. Due to a technicality in the notification law, Law 25, the online sales tax nexus law. Wayfair decision following the U.S. Supreme Court's ruling in South Dakota v. Wayfair states can now force out-of-state online sellers to collect local sales tax if they meet an economic nexus threshold, e.g., selling a certain dollar amount or number of transactions in that state. The true headache is the administrative burden. A small, home-based crafter in Texas now needs to track and remit sales taxes for thousands of different state, county, and city jurisdictions across the entire country. The law is drowning simple e-commerce in paperwork. Law 26, the inheritance of digital assets law. What happens to your lifetime collection of emails, photos, and social media accounts after you die? Many states have passed laws that give the executor of your will access to these digital assets. But with a major catch, this access is often contingent on the original terms of service toes. You clicked I agree 2 years ago. A court-approved will can be legally overridden by an obscure clause. In an agreement you signed in 2008, your digital life is managed by a contract, not your last wishes. Law 27, the hyperspecific deepfake election interference law. Certain states are enacting laws that specifically criminalize the distribution of deepfakes, highly realistic fake videos or audio of a political candidate. The bizarre element is the time restriction. These laws often only apply if the deepfake is published within a narrow window, such as the 60 or 90 days immediately preceding an election. The law essentially implies that a technologically sophisticated falsehood published on day 91 is legally permissible, but on day 89, it becomes a crime. Law 28, local ordinances regulating drone landings. While the Federal Aviation Administration (FAA) governs the airspace, many local cities and counties are passing ordinances that specifically regulate the landing or hovering of drones for commercial delivery purposes. The absurdity is clear. A delivery drone could legally fly across state lines under FAA guidance, but the final 10-foot descent into a customer's yard could violate a local city law. The law is trying to assert control over the sky from the ground. Law 29, the tightrope of online legal advice. The unauthorized practice of law-giving legal advice without a license is a criminal offense in every state. The internet dramatically complicates this. If you run a finance blog and suggest a tax strategy that skirts a legal boundary, are you breaking the law? Could answering a specific, hypothetical legal question on a forum technically be considered a violation? The line between providing educational content and a legally practicing law is terrifyingly thin in the digital publishing world. Law 30, the online sweepstakes disclosure minefield. Running any form of online contest, raffle, or sweepstakes carries a heavy regulatory burden. You must disclose eligibility, methods of winner selection, prize values, and most importantly, the necessary phrase "no purchase necessary." The freaky factor is the sheer ease of violation. Forgetting one minor required disclosure can instantly transform your simple win-a-free teaser contest into an illegal, state-regulated lottery. These are the statutes that betray a fundamental lack of understanding of modern technology, or that apply ancient moral concepts in jarring new ways. Law 31, South Carolina's attempt to ban anonymous websites in South Carolina. A bill was proposed that would have essentially penalized or attempted to outlaw any website that permitted its users to post content anonymously. This bill would have fundamentally violated decades of U.S. legal precedent, upholding the right to anonymous speech. The attempt reveals a deep, concerning resistance within some legislative bodies. To accept the internet's role as a platform for dissent and anonymous dialogue. Law 32. The law against modifying your own game console DMCA. The Federal Digital Millennium Copyright Act DMCA primarily targets large-scale piracy, but its reach is extremely broad. It criminalizes the bypassing of digital locks or technical protection measures on copyrighted materials. The freaky part is the individual application. Technically, jailbreaking your own smartphone or modifying a video game console to run non-approved software could be a violation of this federal statute. The law attempts to prevent you from truly owning or altering the digital products you have legally purchased. Law 33. State laws attempting to define and criminalize trolling. Several states have enacted statutes that attempt to legally define and penalize trolling, often targeting people who knowingly post messages intended to incite, provoke, or harass others. The constitutional challenge is immense. Where is the legal boundary between protected, albeit mean-spirited, speech and illegal, targeted trolling? The law often becomes a clumsy tool used to prosecute individuals whose online opinions are simply unpopular rather than truly dangerous. Law 34. Unsolicited digital explicit material statutes. Many state laws prohibit the transmission of unsolicited explicit material. This law was originally meant to stop physical mail distribution, but has been adapted for digital platforms. The disturbing application is that sending an unsolicited, sexually explicit image via a private message or text can, in some states, be prosecuted as a misdemeanor. The law is attempting to govern private digital communication with the same strictness used for public mail. Law 35. Regulation of online auction. Shilling is the illegal practice of secretly bidding on your own online auction to artificially inflate the price. Many states classify this as a form of fraud. The complexity lies in enforcement. Proving shilling requires subpoenaing online auction platforms like eBay to gather complex IP address and account data, turning a simple transactional dispute into a full-scale fraud investigation that is both time-consuming and expensive. Law 36. Statutes against digital vandalism. Just as physically defacing a wall is illegal, many states have cyber vandalism statutes that criminalize the defacement of a website or digital system. The overly broad language in some of these laws means that simply leaving a nasty or unwanted message on a website's comment section could, under a highly aggressive interpretation, be considered a form of digital defacement, depending entirely on the content management policy of the site and the prosecutor's interpretation of damage. Law 37. The CAN-SPAM Act's physical address requirement. The Federal CAN-SPAM Act regulates commercial email. The truly bizarre requirement is that every commercial email must contain a valid, functioning physical postal address of the sender. The government mandates that your purely digital communication must contain a piece of verifiable analog information. This rule is designed to give the recipient a physical location to send a legal complaint, demonstrating the legal system's reliance on physical geography even for virtual mail. Law 38. Attempts to legally protect video game character likenesses. There have been attempts in various state legislatures to propose laws that would grant intellectual property rights to the likeness of specific video game characters, making it illegal to use their appearance in certain ways outside the game itself. This showcases the legal system struggling to apply physical trademark protection to digital creations, adding layers of legal complexity to simple fan-created content, memes, and cosplay. Law 39. Laws targeting unapproved security software. Some state laws target scareware, malicious software that tricks users into buying it by falsely claiming their computer is infected with viruses. The freaky law is that some of these regulations are written so broadly that they could potentially target any aggressive marketing campaign for genuine antivirus software, blurring the crucial line between effective, pushy salesmanship and outright illegal digital deception. Law 40. The persistence of the spam fax law. TCPA. The federal TCPA, which targets calls and texts, also includes language about unsolicited fax advertisements. The astonishing part is that this law is not obsolete. it is still actively used in court. In the modern era, individuals and businesses still win massive class action settlements, sometimes amounting to millions of dollars for receiving an unwanted, digitally transmitted fax advertisement. It is a powerful, sharp-toothed legal relic from the 1980s that remains surprisingly potent today. These final 10 laws represent the most profound challenges to our assumptions about digital privacy, data ownership, and the permanent nature of online life. Law 41. Criminalizing deepfake revenge porn. Many states have updated their revenge porn laws to specifically include deepfakes. This means it is now a crime in numerous jurisdictions to create a digitally altered, sexually explicit image of someone and publish it, even if the person was never actually photographed in that position. The law has finally caught up to technology by criminalizing a digital lie, recognizing that the emotional and professional damage is just as real as if the image were authentic. Law 42. Vermont's data broker registration requirement. Vermont mandates that data brokers, companies whose business is buying and selling your personal information, must register annually with the state and pay a fee. They must also disclose any data breaches. This law is freaky because it recognizes and regulates the buying and selling of people's private lives as a legitimate utility. Treating your personal data like a publicly traded commodity, it provides a rare, unnerving glimpse into the lack of control you have over your own information. Law 43. The HIPAA Health Data Loophole. The Federal Health Insurance Portability and Accountability Act HIPAA protects your medical information. The legal loophole is critical. If you use a wellness app that is directly linked to your doctor or hospital, that data is typically protected by HIPAA. However, if you use a fitness app that tracks your steps and shares the data with third-party advertisers, that data is often not protected by HIPAA. The law protects the institution collecting the data, not the nature of the data itself. Law 44. Digital non-compete enforcement. In states that permit non-compete agreements, employers can restrict an employee from working for a competitor after leaving the job. The digital application is problematic. An employer might try to prevent a former software developer from working on any similar code base for a set period, essentially placing a geographical and functional restriction on their entire digital skill set. The law is attempting to digitally chain a person's entire livelihood to a single company. Law 45. Regulation of live animal online sales. Many states have complex laws governing the online sale and shipment of live animals, designed to prevent inhumane transport and crack down on unscrupulous breeders. The freaky law is the inconsistency. You could legally sell a pet bird in a physical store, but selling that exact same bird via a state-run online classified site might violate a complex set of interstate shipping, health inspection, and documentation laws. Law 46. Attempts to ban slime videos. There have been attempts in various state legislatures to restrict or ban YouTube videos of people making slime or other popular sensory toys. The concern is that the instructional videos sometimes involve common household ingredients like borax, which can be toxic if misused. The law is attempting to ban a specific type of online content because of the potential misuse of the physical ingredients demonstrated, showing a profound overreaction to a non-digital danger. Law 47. The price gouging application to online sellers following natural disasters or public health crises. Many states activate laws against price gouging. The freaky legal reach is how this is applied to platforms like eBay or Amazon. An individual who quickly buys up necessary items, like N95 masks, and then attempts to resell them at a vastly inflated price on an online platform can be violating a state price gouging law, even though they are just an individual operating from a personal computer. Law 48. The infinite statute of limitations for computer crimes. Most criminal offenses have a set time limit, a statute of limitations within which the government must file charges. The chilling exception for many serious federal computer crimes is that the clock does not start ticking when the crime is committed, but only when it is discovered. You could have committed a minor digital infraction a decade ago, And if it is only uncovered in a forensic audit today, the government can still legally charge you. Your digital history has no expiration date. Law 49. The low legal bar for text message threats while making physical threats is illegal. Many states have specific statutes targeting threats made via electronic means, like text messages. The truly disturbing element is how liberally the term threat can be interpreted. A sarcastic text, an aggressive or angry rant, or an emotionally charged message could potentially be interpreted and prosecuted as a criminal threat under broad state laws, turning a simple, heated exchange into a criminal court matter. Law 50. The absolute power of the click-wrap agreement. This is the ultimate legal reality check. Every single time you click "I agree" without reading the terms and conditions, you enter a click-wrap agreement. The freaky law is that courts almost universally uphold these agreements. You are legally bound by contracts you have not read, often including clauses that waive your right to sue and force you into mandatory arbitration. The law considers that single, unconscious click to be a binding, highly durable legal signature. You have likely signed hundreds of contracts this year alone without knowing their contents. We have explored 50 unique laws that collectively dismantle the comforting myth of digital freedom. The critical moment is the realization that your digital footprint is not only permanent, but it is now fully indexed and accessible by an analog legal system determined to regulate it. Look back at Law 48, the infinite statute of limitations. Your past digital mistakes are not forgotten. They are merely waiting to be discovered. Consider Law 50, the all-encompassing click-wrap agreement. You are legally bound by dozens of non-negotiable contracts you never reviewed. These laws are not abstract. They target you, the consumer, the social media user, the casual online seller. The profound shock is how simple it is to violate a law. You can simultaneously violate a federal spam law, a state's economic nexus sales tax law, and a digital impersonation statute, all before finishing your morning coffee simply by posting a quick update, sending a group text, or selling an old item. The laws are complex, often contradictory, and frequently based on obsolete technology, but their enforcement is very real. You now possess the knowledge of 50 of the strangest digital statutes in the United States. The next time you instinctively click that accept cookies button or post that slightly aggressive comment, remember the vast, watchful, and strangely worded legal system observing every single keystroke. So, what is the definitive takeaway from this journey through the legal labyrinth of the internet? The internet is not above the law. It is heavily regulated by laws that often don't make sense. We have seen everything from font size compliance mandates Law 21 to the lingering threat of a decades-old fax law Law 40. We have examined the attempts to ban anonymity Law 31, the efforts to regulate sarcasm Law 33, and the legal paradox where your will is overridden by an obscure website clause Law 26. The fundamental truth is slightly unsettling. The law is always, eventually, catching up. When you are online, you are not floating in a lawless cloud. You are moving through a legal minefield mapped out by lawmakers at every level of government. The best defense is simply to operate under the assumption that everything you share, click, or sell is being governed by physical rules written by individuals who might still think the cloud is something that holds reign. Stay alert, pay attention to the fine print, and understand that the most mundane click can carry a surprising legal weight. If this deep dive into freaky laws shocked you, subscribe so you don't miss our next investigation.